Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near and give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today are Justice Hershfang and Justice Toone. Will be the panel on all the panel for all the cases today. If you've been here before, you know that each side has 15 minutes. We do not entertain rebuttal. We have read everything, and my best advice is to just get to the point. I have one housekeeping matter. Justice Hershfang, while competing in the Paris Olympics, hurt her back, and she may need to periodically stretch. So if she gets up to do that, I want you to know that it's not a reflection on your argument or you, nor her elaborate means to avoid somnolence. So with that, our first case is 23P 282 SM versus RM, and I'll remind counsel that this is impounded or partially impounded, so no names, please. Ms. Satidi.
Good morning, Your Honors. May it please the Court, my name is Attorney Joanna Stathy, and I represent the appellant who is present here today. The phrase "a second bite at the apple" really comes into play in this matter. Just by brief background, the parties were involved in a contested divorce matter. It is a contentious custody battle, and what occurs is that the plaintiff at the time...
Excuse me, can you just pull the microphone closer? Great.
Sure, is that better?
That's better.
Thank you. And what occurs is that in September of 22, the plaintiff goes to the Worcester Probate Court, seeks a restraining order, ex parte. At that time, the restraining order is denied. Fast forward 9 months later, we're now in Rentham District Court, and the plaintiff once again seeks a restraining order, even though the divorce was pending in probate court, decides to go to district court to seek another restraining order against the defendant. The crux of the defendant's appeal really relies on the fact that what the lower court did in allowing testimony to come in that pertained to that initial restraining order, which was argued in the Worcester probate, went against the doctrine of collateral estoppel and claim preclusion. You'll note that in the transcript, as soon as the hearing starts and before the plaintiff takes the stand, the defense objects to any testimony coming in that would pertain to the allegations that came of the January 22 affidavit. And essentially because those issues were heard, they were argued, the probate judge heard them, and the probate judge denied them.
But there's a problem with the record in that we don't know what was actually litigated. You yourself, on the transcript, admit that you're not sure what happened at the other hearing.
That is correct. It is unclear, but what we do know is what the clerk from the district court reads into the record, in which essentially she says that on January 10th, there's a affidavit that's submitted, there's a complaint that's submitted, and this is page 22 of the record appendix. She goes on to say there's a affidavit submitted, there's a complaint submitted, and it seems that the judge did not order the issue. On ex parte, parties are directed to appear on a scheduled hearing, but it looks like the complaint was denied.
Well, what we know is that there was an ex parte hearing, and there was no follow-up on that, and that's what the record reflects. But we don't know what was actually litigated.
Well, I would offer to the court we do know, because in the record on what the clerk reads...
Do we have a transcript from that hearing?
We don't have a transcript, but we
And
do...
whose obligation was that?
Well, this goes further into the argument. I guess it would be on the defense, but the problem is that there's this affidavit that is now submitted. in which the defense also objected to coming into play because the defense didn't know that the judge at the time had this affidavit. But to go back to Your Honor's question, I would offer that we do know what was litigated at the ex parte hearing because it's the same affidavit. So the affidavit submitted in January 10th to the probate court is the same one that was submitted in this matter. It's the same allegations. It is what the plaintiff testified to. So it's a little different than the case that my brother cites to GB versus CA, where the court in that case says, we don't know what was litigated on those 3 prior restraining orders. And in that case, the defense actually consented to testimony coming in pertaining to those 3 prior restraining orders, consented to video evidence coming in that had pertained to, again, those 3 prior restraining orders. Whereas here, the defense objected right off the bat. As soon as the hearing starts, the defense says, Judge, there's going to be an issue. I believe testimony is going to get into this line of questioning. And this was already heard in the probate court.
I don't take issue with the fact that the claim is preserved. That is true. But without an opportunity to litigate or for us to know what was litigated, it's impossible to preclude additional litigation on that issue.
But again, I would go back to the affidavit. We know the January affidavit was submitted to the probate court. We know that because the clerk reads that on the record, that there's an affidavit submitted. The allegations that were contained in that January 22 affidavit were the ones heard at the ex parte hearing because that was the one that was presented with her restraining order. We know that.
Did the plaintiff testify at the ex parte hearing?
It's unclear whether the plaintiff testified, but the judge does say there's an order not issued. I think we know that ex parte hearings are pretty substantive where a plaintiff once submits an affidavit, which the plaintiff did here, we know that, and then 2, there's a hearing, a short hearing that the plaintiff testifies at. And again, just going back to what the clerk reads, it's clear that the affidavit is presented. So even assuming even the plaintiff not being in front of the probate judge and not getting the opportunity to be heard, her affidavit is still in front of that probate judge. And that affidavit is written by her, it's signed by her, it's under the pains and penalties of perjury, so she is presenting her side to the judge. Again, just going back to the claim preclusion, it's on the plaintiff to show that she did not get an opportunity to present her facts at the probate court, which is not what we saw here on the record. We saw that she did submit the affidavit, and that affidavit was taken into consideration by the probate judge, which denied the ex parte restraining order.
I think there's some slippage in your argument between the notion of a claim and the notion of evidence. The claim at the point that your client is now contesting is a claim that at the second, in the time of the second restraining order, that the other partner was in reasonable fear of imminent serious bodily harm. That is not the same claim as a claim that months earlier the partner had felt that. Some of the facts are the same, in other words, the historical facts, because time goes on and more things happen. Do I hear your argument to be that once certain facts have been presented to a court in connection with one claim, those facts can't be presented again in connection with a claim based on subsequent events?
So I think there's a bit of a difference. I think if a claim is presented to the court, which is heard and then ruled upon, then I would offer to the court that, yes, that claim should not be able to come forward because it was already heard once by a district court judge. To permit a claim to come forward again once it's heard and ruled on by the probate judge, by a different judge, I think would encourage the notion of forum shopping. But in terms of whether maybe a claim was not heard and we're bringing up evidence from the past, I think the courts are permitted to hear, it's one of the factors, the courts are permitted to hear what has occurred between the parties under the Amali case. But it doesn't negate the judge from finding that there has to be an imminent fear of physical harm. And in this case, the judge is very clear when you're looking at the plaintiff's current restraining order, the most recent restraining order, there is no imminent fear of physical harm. But what the judge says is in looking at the past, in that affidavit that she had submitted to probate court and what she testified to, which were the same allegations, that he did find that there was an imminent fear of physical harm. And mostly because of the Amali case, what he quotes is that the Amali case gives him the right, if he hears abuse, to, without a question, extend the restraining order, which I believe is an error of law. And we know that because first...
It says but he makes findings on the motion to reconsider that cleans that up quite a bit.
He does, and I would offer...
He says the court has satisfied the plaintiff's description of past physical abuse coupled with the ongoing hostility in connection with child custody and divorce proceedings warranted extension of the order.
I understand, and that was cleaned up, and there was a notice of appeal, unfortunately, at that time pending when order came out. But I would offer to the court that was never said at the initial restraining order when it was extended. I believe...
But it was your motion to reconsider.
It was.
And he answered it, and he gave more explanation.
He did.
Assuming there was an error, that he corrected it.
But it still doesn't negate that his initial, I guess, reasoning for extending the restraining order was based on what he quotes, the Amali case that gives him, without a question, the ability to extend a restraining order based on the abuse that he heard. Now, I would offer the Dolan case, which actually goes in contradiction with that, which says that you can't use past abuse to fulfill this requirement of having an imminent fear of physical harm presently. So again, putting aside the affidavit, even allowing this testimony of her to come in from the past, the judge cannot use that past physical abuse to establish a current imminent fear of physical harm.
By itself, you can't use it, but you can use it as part of the totality of the circumstances. That's what Amali itself says.
Again, but part of the also totality of circumstances is taking a look at all the other factors. And when the judge cites his reasoning as to why he extended the restraining order, he doesn't really cite the additional factors until we get to the motion to reconsider. What he says is, again, there was past abuse. I'm going to extend this because of the Amali case. Now, the Amali case, again, as Your Honor had said, there's a totality of circumstances. So there's factors. There's her credibility, which was, there was a great question as to her credibility at trial. There was numerous impeachments, which are outlined in the brief. There's also the notion of forum shopping, that she got a second bite at the apple because she went to probate court that knows her case, did not like her outcome, and then 9 months later, even though there's still a pending probate case where she could have gone, she then goes to the district court. And since then, the probate court has found her allegations to be not credible of the domestic violence. So this is the issue that bringing in, and going back to Your Honor's question, bringing the issues up of allowing past abuse to come up if it's already been litigated and decided upon, again, I think creates a floodgate to allowing plaintiffs to forum shop, and that's the concern. The other issue, Your Honors, were whether there was a meaningful opportunity to be heard. The record, it's a little tricky because we go off the record in the transcript, and you'll see the judge say, I need to get a drink of water. And it goes off the record, and it's realized that the judge has the affidavit from the probate court, which counsel had never seen before, didn't have a copy of, was not aware how the judge got that. It's still a little confusing how the judge had that in his possession, but I would offer the court under Idris versus Hazel that it wasn't a meaningful opportunity to
Did you raise this in front of the judge and say we really need some more time to review this affidavit?
So I did not raise that in front of the judge, but in looking at the case of Idris versus Hazel, what the case says is, and while the lack of a further objection in a civil case may constitute waiver, that principle does not control in a 209A because of the unique nature of those cases. And it goes on to further footnote 9 to say that if any additional objections by the defendant's attorney a party need not continue to voice an objection once it's clear that doing so would be pointless. I'd offer to this court, it would have been pointless because there was such an extensive objection off the bat as to any of the testimony coming in as it pertained to that affidavit. and over again, I think there's numerous
You did a
objections.
pretty extensive cross-examination of SM.
I did, but again, I think having had an opportunity to,
What do you know now that you didn't know then that you would have done?
possibly subpoena the police officers. There was numerous mentions of police officers that potentially drove her to the courthouse. There was witnesses that could have probably testified to the contrary. And it really does come.
Who are those witnesses?
The plaintiff had presented, the plaintiff, I believe, had referenced possibly the son having witnessed some of the domestic violence. There was a GAL in the probate.
Was this also in the motion to reconsider?
This, I'm sorry, which part?
The not having enough time to prepare and what you would have done.
I don't believe what I would have done was in there, but the request for, or excuse me, the notion of a violation of his due process rights for not having the time.
Ask it differently. Is it in your brief what you would have done if you had more time?
It is not in my brief, Your Honor.
So you just say we didn't have enough time, but you don't spell out the consequences.
Well, I didn't spell out the consequences because I stuck to the record, and that's why the consequences aren't there. I can tell Your Honor today that the consequences are serious in the probate court, which that part is in my brief, that it leads.
No, that's why I thought you should have raised it in your motion to reconsider. Then it would have been on the record.
It's probably not in my motion. I have a hard time believing I probably didn't raise it in oral arguments on the motion to reconsider, which I understand Your Honor doesn't have the transcript of. But there were consequences, and the custody piece is highlighted in my brief. There's also consequences to his job because he is a police officer, as noted in the record. But I do see my time is almost up, and if there's any additional questions,
Seeing none, thank you.
I'd like to rest on my brief. Thank you.
Mr. Murray.
Good morning, members of the panel. My name is Sean Murray, and I am counsel for the appellee in this action. I would just like to touch briefly upon the claim that the lower court erred in considering the January affidavit and the claim of res judicata. As an initial matter, I would suggest that the case law is abundantly clear that the court must consider the totality of the circumstances and the entire history of the parties' relationship when deciding whether to extend a restraining order, and that proposition is supported in the cases cited in the papers I submitted in Umelli versus Acelen, GB versus CA, and other cases. I would also point to this.
Well, you don't deny that issue preclusion could apply in this circumstance if there was a full and fair opportunity to litigate the issues
I would not deny that.
Okay.
I would also direct the court's attention to the statute 209A section 7, which does require a judge to do a search of the records in the domestic violence database prior to a restraining order hearing, which is exactly what the trial court judge did in this case. As far as
what should a court provide in terms of due process when it does this record check and come up with a new affidavit and sort of presents it to the parties? If there's a request for more time or discovery, is that something that the court should take seriously? I mean, there does seem to be a due process problem when you go and you comply with the statute and you find an old affidavit that hasn't been brought to the party's attention until that period. So what should be the general rules and how a court approaches that?
I appreciate the question, and I think a motion to continue or motion for more time would be appropriate for a court to consider under those circumstances. There was no such request in the instant matter. The court did recess, allowed the defendant the opportunity to review the affidavit, and then a thorough cross-examination was conducted relative to that affidavit and the other claims in the second affidavit filed in the Rentham court. But I think as far as the res judicata issue, I think it is incumbent upon the defendant when raising that issue to establish on the record that the matter was actually litigated in the prior proceeding. And the record before the trial judge and the record before the panel here today suggests more likely that there was never a two-party hearing. When directly asked by the court about what happened in the prior court proceeding, the plaintiff herself testified that the matter was never heard. Plaintiff's counsel testified that it was never heard for extension, and defense counsel indicated she was not, was unclear as to what occurred. So I think it would be fair under those circumstances, there was no transcript, there was no docket sheet for the trial court to take all of that information and conclude that the matter was never litigated. And I think that is a reasonable interpretation based upon the information provided to the court at that time. Now, the GB versus CA case, which was cited in the brief, in that matter, there were 3 prior two-party hearings in which this prior claim of physical abuse was presented, was litigated, and notwithstanding that being on the record, the court concluded absent a full transcript and record of what occurred, they could not consider the claim preclusion under those circumstances. So I would suggest that the claim preclusion fails and that the trial court acted appropriately in considering that first affidavit. With respect to the claim that the court wrongly applied the Yamelli case, I think as noted in the motion for reconsideration in that decision, the court correctly stated that a finding of past physical abuse would not mandate an extension of the order, but indicated that a finding of past physical abuse coupled with the ongoing hostilities noted in the testimony would justify the extension of the order, and he so concluded. So I would respectfully suggest that understanding the discretion of the trial court under all these circumstances, the decision should be affirmed.
Thank you. Thank you both. We'll take it under advisement. Our next case is 23P 1096, Alfonso Longobardi versus Gulfstream Aerospace Corporation. Ms. Smith-Lee.
Good morning, Your Honors. Do you mind if I help myself to some water
Go right ahead.
before I begin? Good morning, Emily Smith-Lee for the appellant, Alfonso Longabardi. I'll take you at your word that you've read the materials and try to dive in. Fundamentally, the holding in Cowders is that we're required to look for reasonable notice and reasonable manifestation of assent. Importantly, as confirmed by decisions following Cowders, this is not a checkbox activity. You know, where there is a hyperlink does not mean that everything else is satisfied. It is an examination of the totality of the circumstances. Here, just briefly, there's 3 interactions Mr. Longabardi had with Gulfstream leading up to his employment. There was an online job application, which included a paragraph stating that he agreed to abide by the dispute resolution policy. The dispute resolution policy was not linked to that job application, and there was no further explanation of it. This was in the context of a 14-page online application, which Mr. Longabardi filled out and was not given a copy of. A month later, having accepted the position at Gulfstream, he was presented with some onboarding materials. And I'm doing this in summary fashion. It's more detailed in the brief and happy to answer questions. But when it comes to the DRP, there was a list of 8 hyperlinked things that were all referred to as policies. Within those was a link that allegedly led to the dispute resolution policy. The rest of them were what you might call garden variety employment policies.
Well, I mean, I'm not sure I can agree with you on that. You know, combating trafficking in persons doesn't seem garden variety. Business conduct and ethics, use of computing systems, equipment, and support. I take it, having started a job or two in my day, that included in some of these policies are requirements whose violation could result in serious adverse employment consequences, right?
Oh, Your Honor, I agree, and perhaps I should be more clear what I mean by garden variety.
Okay.
And let me jump to another point. I think words matter here, and the words policies versus contract or agreement matters because I would suggest an ordinary person understands a contract or agreement to mean we each say we're going to do something and they can be legally enforced if we don't do our things. Whereas a policy in the employment context, I think you're right, everybody understands if you violate an employment policy, you can be fired, you can be disciplined. But they mean different things if you are the user looking at it saying, okay, fine, I've got to abide by company policies, versus I am agreeing to a dispute resolution policy whereby I am giving up my right to the court system, giving up my right to a jury trial if there is a substantive dispute around employment. So my argument, when I say garden variety, I think I mean things that are not recognizable as contracts, but that employees would expect to be policies.
But starting a job is a big deal. And in starting a job, I think most people would understand, even if they're not lawyers, that they have entered into a contractual relationship with their employer, right? They're going to give a certain amount of their time and energy and maybe intellectual property, depending on the job. And in return, they will receive a salary and whatever other benefits are allowed. And that there are additional requirements as part of that, what they now call onboarding procedure. And you have to learn about, you know, if you show up to your job wearing the wrong thing, depending on your job, that could have an adverse effect on that relationship with your employer. So I guess, do you see cases in which the decision turns on the use of this word contract?
I do not, to be honest, Your Honor. However, the cases, you know, Cowders and its predecessors and progeny do speak of language that clearly puts a user on notice that they are entering a binding agreement.
And so if you look at the language here, and I'm on page 68 of the record appendix, at the very top, before those boxes, each of which your client did click, correct? It says, by selecting the check box of each policy, I acknowledge that I have read the policy and understand how this policy affects me and understand the guidelines and requirements of each. And then underneath is the language I think you cited earlier, I'm expected to comply fully with the policy set forth. Collectively, that seems to me to be at least as much as is required in the other click wrap cases that I have seen coming out of our Supreme Judicial Court.
I would argue, Your Honor, that what's important is what that paragraph suggests to Mr. Longabardi that he is agreeing to, and all of the words that you just read suggests that he's agreeing to abide by company policies. There is not any language in there other than what I would argue is kind of an ambiguous little I agree button in the corner that says, that suggests that he understands that he's agreeing to a contract that has a life beyond his employment. A dress code policy, for example, you agree to comply with it, you don't comply with it. Yes, you're in a sort of quasi-contract or contractual relationship of employment, you get fired. An arbitration agreement, in contrast, lives beyond the termination, lives beyond what happens in the four walls of employment and takes that extra step of constraining how you get remedies and how you address things that you think were unlawful that happened in employment, it's not clear from that paragraph and these policies, these 8 listed policies, to a reasonable user that that is what's at stake when he clicks, I agree. In contrast, the click reps that are considered to have given reasonable notice have things like terms of use and have things that actually require users to look at them, as opposed to this, which is just like, check, 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 yeah, I've looked at them.
But we know from the law that once you check something that says, I have read this, it doesn't matter if you have chosen not to read it, right? As long as you have had to check it to move on, which is the case here. He could not take the next step in his onboarding without checking these boxes. And he certified that he had read it, so.
Oh, agreed, Your Honor. The significance of not being required to read it goes to the notice part of the Cowder's test. You know, if Mr. Longabardi were to sit up here and deny that he checked that box, that would be a hard position to maintain. That doesn't mean that the totality of that form put him on notice that he actually needed to read that one particular policy to understand what his rights were during and after employment with Gulfstream.
Is it your position that Cowder's requires that the user actually engage with the terms and there not be an opportunity for him to check the box without actually pulling up the hyperlink?
I wouldn't go that far, Your Honor. I think Cowder's would stand for you don't have actual notice if you're not required to interact with the terms in that way. However, if you look at the factors that they then go through for the reasonable notice, you know, among them is the extent to which the person has, and I'm not looking at the language right now, but they're outlined in our brief, factors such as how clear the notice was, but also did they in fact read them. So it's relevant
Well, what
to the
would be
reasonable.
sufficient, assuming that the policy was set forth just in a hyperlink, and that the user, the employee, did not have to open? What else would be sufficient, in your view, to make that sufficient notice under Cowder's?
Fair enough. So just so I'm clear, assuming no required scroll through.
Assuming no requirement to actually open the hyperlink, there's no,
Yeah.
you know.
I would argue that under Cowder's and related cases, what would have been sufficient is a standalone screen that said dispute resolution and arbitration agreement with a hyperlink. If not a standalone page, something that broke that away from the other employment policies and clearly said something like agreement or contract or, you know, preferably arbitration agreement, because that's what we're talking about here. That's the post-employment obligation we argue he did not have notice of. And frankly, Gulfstream could have done that easily. You know, and I think we make this point in our brief. You know, what they've got is all these little pieces of arguably Cowder's compliant things. There's a paragraph in the job application that says you agree to a dispute resolution process. There's a little button that says I agree. There's a title of a document that has a hyperlink. But when you put them all together and you look at that sequence of events, they each fail in some respect, and it almost has the feel, candidly, of let's put this together so that it withstands scrutiny, not so that it gives our employees reasonable notice.
Ask you this, though. Correct me if I don't have it right, but not only was there a link, but he clicked in the acknowledgement. He checked the box that he read and understood the dispute resolution policy.
He did, Your Honor. And
Why doesn't that make it at least objectively reasonable that he understood, since that's what he acknowledged?
Well, I think under Cowders, those factors would say that would count if he was clearly on notice that checking that box meant he was checking a box about an agreement or a contract or something of that kind of legal significance, which where it is on that page and where it is in the onboarding process, and let's be real,
Isn't within the dispute policy itself obtains components of what must obviously be legal claims or disputes?
the actual policy?
Yes.
Yes, for sure.
So, and he acknowledges that he read and understood it. I mean, it seems hard to get by that alone.
So that would, I think, Your Honor, respectfully, I think that's conflating the two prongs. I think there's the two distinct prongs are reasonable notice and reasonable manifestation of assent. And I would suggest that what I'm arguing to you right now is that that was not reasonable notice. Had it been reasonable notice, as you know, what I'd suggested in response to Justice Toone's question, had it been reasonable notice and he'd clicked a box and chosen not to actually read it, yeah, under Cowders, that would be on him.
So if I understood correctly, it had to be on a separate document for it to be reasonable? Or is that one way to make it more reasonable?
That's one way to make it reasonable. I mean, I might not be here arguing with you about this if that's what had happened. Whether it had to be a separate document or somehow called out, or even called an agreement. Oh, sorry. Had it been called out such that checking that box would have led a reasonable person to understand that they were checking a box about a legally binding agreement that transcended their employment in whatever way, whether it's a separate paragraph, better title, separate page. But again, I think, and I'm running out of time, but the primary focus here is the reasonable notice. I would also say, just the observation in Cowders that I'm paraphrasing generously, that where the connection between the act that the person takes in assenting to an online agreement and the consequences of that act are attenuated, then I believe Cowders' language was something like, it will be difficult to establish reasonable notice and manifestation of assent. I would suggest to you that when you take the overhead light to this, not just the pen light to each of the little things, that connection is so attenuated.
Okay, thank you.
Thank you.
Ms. Letterman.
Good morning, Your Honors. May it please the Court, my name is Danielle Jerema Letterman, and I represent the defendant appellee, Gulfstream Aerospace Services Corporation. I represent to the Court that the plaintiff unequivocally agreed to resolve all of his employment-related disputes pursuant to the DRP, the dispute resolution policy. As my sister identified, the two-pronged test is easily met by Gulfstream here, even if you're just focusing on the new hire policy acknowledgement form, which is in the record appendix, but also attached to Gulfstream's addendum because that appears in color so that you can see more easily the blue underlined hyperlinks. It's very clear that the dispute resolution policy is a hyperlink that's not disputed by the plaintiff at all. So turning first to reasonable notice, plaintiffs write that it is a totality of the circumstances test, but we've met that here. The nature of the transaction, as Justice Hershfang pointed out, it's in the employment context. That's different than Cotter's, that's different than Cullinan, where they were both dealing with Uber agreements for the users of the ride-sharing app. The employment context is different. It's based on one's livelihood. When you look at this acknowledgement form, it's very clear that it's a contract. We've been talking a lot about clicking boxes because of it being a click wrap agreement, clicking the link to the hyperlink to see the DRP, but there's also an electronic signature. It's very clear that plaintiff was signing a contract. He had to type in both his name and electronically sign that form. And the last sentence on this very simple, uncluttered one-page form is, by electronically signing this form, you agree to all of the terms contained herein.
Well, in Cotters, the Supreme Judicial Court found problematic the Uber click-wrap interface, and one of the points they made is the interface did not require the user to scroll through the conditions or even select them. The user could fully register for the service and click Done without ever clicking the link to the terms and conditions. And that's true here, right? That it was entirely possible for an employee to click I agree without actually opening up the hyperlink that had the dispute resolution policy.
That is correct.
Right, and so that's a problem, right? This doesn't make your case unequivocally strong, because if you had an interface where they were forced to engage with the policy before they said, I agree, that would be a much stronger position for you, correct?
That would be more clear, I agree, Your Honor. But here, instead of having to click on the hyperlink or somehow internally confirm that that happened, Mr. Longabardi had to click next to a box indicating essentially that he did just that he clicked on the hyperlink, because he's asserting that he has read each policy and understands how the policy affects him. So by having those check boxes, he's saying he read and understood the policy. So that's sort of what's built in to the acknowledgement form to indicate reasonable notice of the policy. In addition, there was no time limit for him. This wasn't someone trying to call a ride through Uber and possibly being more pressed for time. This was part of the employee onboarding process. Mr. Longabardi had all the time he needed to read any of these policies, including the DRP. The interface itself, as I said, it's one page, it's simple, uncluttered. The hyperlink is very prominently displayed, and it's specifically...
Can I ask you, does the hyperlink do a pop-up? If you hit the hyperlink, does it come up a pop-up in a new window, or does it go to a different document that you have to then scroll back to get to the original thing? How does that work?
I'm not sure, and that's not in the record, Your Honor.
You agree it would be easier if Gulfstream had an onboarding process where you actually had to engage the content of the policy before you said I agree, right? That would make this issue a lot easier.
I agree it could be easier, but I don't think that's needed to meet the reasonable notice standard of a reasonable person starting a new job and signing this document, acknowledging that he's read these policies and agreeing to be bound by all of the terms contained herein.
What's your response to the argument that your sister makes, that this is a really fundamental issue about you losing your right to go to the courts to raise disputes, and that it's kind of buried in policies about workplace attire and timekeeping and things like that, that this is kind of an issue that's more fundamental that needs to be done in an interface that makes clear that you are actually signing away your right to seek relief in the courts if a dispute were to arise, that you need some kind of separation between that and other kind of garden variety workplace policies.
I wouldn't characterize these policies as garden variety. I mean, one is workplace conduct and harassment prevention. I'd say these are very significant policies, and that the acknowledgement is calling out these specific policies. This is by no means all of the policies that the company has in place. This isn't a link to the employee handbook, which could internally contain the dispute resolution policy. It's specifically calling out these 8 policies in particular, and the dispute resolution policy is one of those being called out. In addition, a reasonable person, when looking at this form that needs to be electronically signed, that requires the checking of the box that you've read and understand each, and the clicking of the I agree box at the bottom, a reasonable person would look at this like it's a contract, because it's something you're required to sign as part of your employment. And the interface itself is simple. While I'm not sure whether it opens up in a separate page or exactly how it opens, it's in the record in Sir Leonard Waits' affidavit that clicking on this link to the DRP does take you directly to the DRP. It's not as though it's a multiple-step process.
Another problem with your position, I think, is that both the SJC and Cotters and the First Circuit and Quilane, if that's how you say it, discuss the hyperlink's capability to grab the user's attention, right? And here your hyperlink is policy CP-6-56: dispute resolution. Who in the right mind would click on that? I mean, that's not a very alluring link. It seems very bureaucratic and designed to kind of obscure what's going on here.
So I would say, Your Honor, that's part of the reason I would imagine Gulfstream has these checkboxes next to each policy. So when you click on it, it's very clear when you look at the DRP, and plaintiff isn't arguing to the contrary that the DRP itself is insufficient to be a valid and binding arbitration agreement. It's really whether or not he's gotten there and manifested his assent to it. So because you're supposed to, required as part of your employment to click on each of these policies, acknowledge that you've read and understand them, and then signed this document, also clicked the I agree box saying that you agree to all of the terms contained therein, I think that gets us past any potential confusion for the title of the policy. Though I would say dispute resolution is not an uncommon term to discuss the concept of binding arbitration, and employees that have worked at multiple jobs would not be confused by that, and I think a reasonable person would read that and understand that that's what that was talking about.
I mean, I think if you want to really inform your employees what you're doing, you'd have a link that said, all employee disputes shall be resolved through arbitration or something like that, and then I would click on that. It's like, oh, what does that mean? I'm not sure I would necessarily click on policy CP-656.
Or they could just call it like free lunch every Wednesday, and then people would
Right.
definitely click on
Yeah,
it.
that would be interested in that as well.
And, Your Honors, just to the extent we're talking about how you manifest assent here, there were several actions required. So we've talked about reasonable notice, and I believe that this interface, just the nature of the employment transaction, and the fact that the notice is conveying the full scope of the terms because it's a readily identifiable hyperlink. This isn't hidden in fine print in Cotters and Cullinan, and the Cullinan decision actually includes a picture of what the interface looked like if we wanted to do a comparison. It was very unclear that a hyperlink was even there. It was a gray box with white bold text that didn't really stand out from other things. There were also instructions that had a link to a payment. So it was much more convoluted than what we're dealing with here. This case is much more similar to Archer versus Grubhub, which is cited in our papers, and the Emmanuel case also cited in our papers, both involving the employment context, both involving multiple steps, similar to this matter where there's multiple things that needed to be checked, right? He had to click that he read and understood it, he had to click that he agreed, and he had to electronically sign the acknowledgement form, all to create a contract. Do you have any other questions, anything?
You done? Oh,
Sorry.
Just all.
I just wanted to confirm the dispute resolution policy applies only to covered claims. I take it that there is no dispute that this was a covered claim under the policy.
That's correct, Your Honor.
Good. Thank you.
I'll rest on my brief.
both.
Thank you.
Our next case is 23P1188, Green Paradise Services versus Hatch Landscape Design. Mr. Parks.
Good morning. This is William C. Parks for the appellant in this matter.
Mr. Parks, can you?
I'm sorry.
There you go.
These podiums were not designed for a man my size. Can you hear me now?
This Toone knows your pain.
I sympathize.
Well, very good, very good. So this is William C. Parks for the appellant Hatch Landscape and Design in this matter, and we have two issues that are presented to the court today. The first is whether there was a 93A violation when the evidence that was presented at trial supported a breach of contract only, and the jury's verdict demonstrated that there was a valid dispute as to the amount of the services owed. Now, that first issue is potentially dispositive of, because we're appealing the 93A multiple damages and the attorney's fees and costs award. However, we have a second issue, which is regarding whether or not the attorney's fees and costs were supported by contemporaneous evidence and whether the court should have denied those as a result of that.
Excuse me, Mr. Parks, you're not appealing the verdict on the breach of contract.
That's correct, and that was argued below. Since that time, we decided there's a certain amount of time and space in this court, and we decided not to pursue that appeal. Since that time also, there's an argument in the appellee brief that my client has paid nothing. Since the appellee brief was filed, we have paid $100,000 by agreement of the parties as security pending the appeal. So there were some post-trial motions, and I think that's in the record, and we ended up resolving it that way. So what we're here for is the 93A claim. So the court denied our J&OV motion on that issue, and that is subject to this court's review for abuse of discretion, and, clear error under the Cassavant case. Whether facts rise to the level of a 93A claim is a determination of law. The attorney's fees issue is an abuse of discretion issue. So the judge's findings in that motion only prove a breach of contract claim, which is failure to pay without justification or excuse. The findings and the argument that are made by my brother are that Green did a good job, they substantially performed, that my client only partially paid Green, that my client was paid by their customers, in other words, that they had the ability to perform, that they didn't tell Green why they were not paid. And all of these are just rehashes of a breach of contract claim, failure to pay without justification or excuse. The jury's verdict was $80,000 of contract damages, $80,000 of 93A damages, and that the violation was willful and knowing, so therefore it was multiplied by the court, and there was an award of attorney's fees and costs. The Costa case, which we argued below is an important case for this matter, there was one damages award for both 93A and contract, and that's what the court did. The court didn't enter separate damages, $80,000 for both. What the Costa case says, if the same violation was both breach of contract and 93A, then there's a preference for the 93A claim to be retained. But Costa goes on to say that in order for that to happen, that the plaintiff appellee has to argue facts that plausibly give rise to a 93A violation. And that's at 463 Mass 73.
Can I just jump ahead here? So
Yes.
The special jury verdict form was a little confusing, but it seems like you all cleaned it up with the amended judgment. And so really there's the $80,000 in contract damages, and then there's an additional $80,000 awarded under 93A, sort of double damages, correct? Those are the two damage awards. And then there's pre-judgment interest, post-judgment interest, attorney's fees and costs. Is that correct?
Well, there was an additional part where the jury was asked to do a calculation for how the damages should be multiplied, and then they went on to do $160,000 of multiple damages.
Right, but my understanding is that you all sort of fixed that issue and sort of reinterpreted the jury verdict through the request for an amended judgment that essentially said $80,000 contract, $80,000 double damages under. Is that right? Is there anything more that I'm missing?
I don't agree that that's correct, and not exactly. So what happened was this, is that the court retained the 93A claim. So $80,000 of 93A damages, $80,000 of double 93A damages, if the court follows me. I think that's a more accurate summary of what happened in order to avoid a duplicative recovery for the same facts, contract and 93A. That was what we were arguing under the Costa case, that the damages were not separate.
Okay, well, how much is awarded under the amended judgment for 93A?
I believe it was 80,000 of singles, 80,000 of doubles, 70,000 of approximately $70,000 of attorney's fees and costs. I believe that's the correct figure. I think that's right. The court, I don't have the judgment right in front of me, but I believe that was the figure. Going back a little bit, the plaintiff, the appellee, argued at trial that they were owed $90,000 under the invoices that were submitted. Our defense was that these invoices for services were inflated, that they had been increased in terms of hours and salt. This was a snow plowing services contract. And the jury awarded $80,000 under the contract. They didn't accept that my client was excused from performance. They found that Green had substantially performed, but they did accept our dispute as to the amount of damages. So under the Levings case, there cannot be a 93A violation if there is a legitimate dispute as to the damages as the amount owed under a services contract.
Well, I'm not sure we can infer from the amount of damages awarded that the jury actually found that there was a legitimate dispute, that we have to assess the evidence in the light most favorable to the plaintiff, and that certainly there is a favorable interpretation of the evidence is that Mr. Hatch did not provide any reason for not paying the invoices after January 2019, I believe it is, right? And so there was essentially radio silence. So the question, though, is, I mean, so I think there's the jury verdict supports the finding that Hatch stiffed Green Paradise on the remaining amounts of money. The question is that a 93A violation? And your argument is, no, that's just a contract dispute. Is that your position?
Yeah, I don't necessarily think that it's correct to say stiffed, but certainly breached. And yes, we are arguing that that was a breach of contract, that the only thing that was done here was that there wasn't a payment. I think it's difficult for the court to see how the court could come to any other conclusion based on the evidence that the jury accepted that Green Paradise was not owed the full amount of its invoices and that therefore the damages were less than what they were seeking. From that, it's hard to see from where I'm standing how there could have been any other reason why they would reduce the damages from what Green Paradise was seeking. The appellee makes a couple of arguments that I want to address. The first one is regarding the partial performance of Hatch. My client paid some of the invoices, but not most of them. And the appellee argues that that was a 93A violation because of this partial performance, that there was something misleading or deceptive about those payments. And we haven't seen case law in this business context where partial performance like that by itself was held to be a 93A violation.
I think the argument, as I understand it, is that Mr. Hatch made authorized initial payments at the start of the winter. And as a result of that, Green Paradise didn't look for any other customers. Said, oh, okay, we have a good gig going for the rest of the winter, and so we're not going to seek any more customers we're just going to rely on the customers provided through Hatch. And then after January 2019, Hatch cuts off the payments. And so as a result of that, not only they're not getting paid by Hatch for the work that they continue to do, but also that they lost the opportunity to retain other customers on their own and get paid for those. So is that a potential 93A violation?
I don't believe so, Your Honor, because of the court should not hold Hatch liable because they made partial payments. Even if that were the argument, which I'm not sure has been raised as in that way, that they didn't seek customers. It's not unusual in this business context for there to be partial performance followed by breach, and that happened in the Costa case. a subcontractor was hired and was paid for a while, and then there was a different act that was a 93A violation. And the court could just as easily make the same argument, saying that by entering into the contract itself, that Hatch was somehow misleading them because they thought that they had a contract. But that I think goes too far in terms of a distant inference as to whether this was intended, any of this was intended to mislead them. You know, if the court were to make that argument, then anyone could enter into a contract and say, as a result of this, I lost opportunities when it didn't work out, or something else happened because of a breach, and therefore that was a 93A violation. If the court accepts this argument about the partial payments, then my client would be in a better position today if they'd never paid anything at all. And if the purpose of the 93A statute is to deter this kind of behavior, that seems not to deter it, but rather to encourage it. What the court would be sending the message that, well, because, you know, if you partially perform and then breach, it's worse than if you never perform at all. There's a second argument that's made by the appellee that this was an act of leveraging designed to incur benefits or secure benefits for the breaching party. And the problem with that argument is that the only benefits, supposedly, were that they weren't going to have to perform the contract. The case law doesn't support that. And, for example, in the Pepsi-Cola case, there was a breach. It was intended, they withheld a payment in order to obtain a different benefit to secure further product to be paid for them. It wasn't just a breach that we're going to be able to not pay the contract. We're going to be able to get something else. The Wang Labs case is closer. There was a gentleman who was performing services who was not paid, were continued to be accepted. But in that case, there's no indication that there was a dispute as to the value of the services. They were calculated as tax savings. It was a mathematical formula.
I'm sorry, Mr. Parks. I mean, the testimony from Mr. Amaral, is that how I say it?
Amaral, I believe.
Yeah, Amaral is that, and we have to credit this testimony in our review of your motion, is that he couldn't get any response. He kept sending invoices, he sent a 93A demand letter, and it was radio silence. No one ever explained to him, oh, we don't think that you're using the GPS, we don't think you're doing a good job. The evidence, in fact, was that all the customers thought he was doing a good job, and they fully paid Hatch for his services. Mm-hmm. So I think his argument with respect to 93A is, by getting complete radio silence from the counterparty, that was implicitly, he viewed that as leverage, that he had to negotiate a lower rate for what he was entitled to under the contract. Is that an inference that we can make to support a 93A violation?
I don't believe so. What happens in these cases, in the case law, is that, you know, for example, in Pepsi, there was an explicit demand that before, you know, I'm sorry, what maybe wasn't Pepsi, but what happened, the silence wasn't communication. If you think about it this way, they're arguing that this was a negotiation attempt to try to get leverage, but there's no evidence in the record that they said, you know what, we're going to withhold payment unless you accept a discount. And that's what's been argued here, is that they were going to do that, but the only support is that there was non-communication at all. And our position is that that doesn't go far enough to establish a 93A violation. They would have had to take some sort of affirmative act, not do nothing.
We're going to have to leave it there. Thank you, Mr. Parks.
Thank you.
Mr. Sinrich.
Thank you, Your Honors. Scott Sinrich for the plaintiff, Green Paradise Services. May it please the court. Before I begin my argument, I'd like to just correct the record on a couple of things. There is no formal settlement on this contract, I guess acquiescence. The post-trial, there were some motions for security, and in lieu of security, after half a decade after the plowing was done, some payments were made. Secondly, the amended judgment has nothing to do with the contract damages or the 93A damages. There was a miscalculation by the clerk, and the council worked together cooperatively to correct that.
Can you just clarify the amended judgment? Am I wrong in saying the amended judgment says there's $80,000 for the contract claim, additional $80,000 for the 93A claim?
That's correct.
Right, that's what we're talking about here.
That's correct.
And then there's fees and interest, but that's essentially the two pieces of the damages that we're looking at.
So there wasn't 80 plus 80, meaning single damages of 160. The 80,000 overlapped. It was both contract and 93A damages, and then it was not the judge, but the jury in special question 10 that doubled the underlying single damage.
But just to be clear, when the jury says 160 for the 93A, that ends up being just the foundational 80,000 on the amended judgment, the 80,000 for the contract damages, and then an additional 80,000 for the double damages under 93A.
Right. Okay. The double damages got it to the 160.
Thank you.
So in the argument before us, there was the phrase garden variety was used to discuss the contract in that case. And I would argue that this is a garden variety 93A action. We don't even need to go into the issue of what other business Mr. Amaral, the owner of Green Paradise, lost, because there's probably a half a dozen reasons that would justify the jury's finding of a 93A violation. So I don't need to say it, it's clear the standard on clearly erroneous is whether there's any evidence or a combination of factors that would support the jury. And here there clearly was. The findings are that both companies were engaged in business. One was the general, one was the sub, that Hatch acted in bad faith in multiple ways. They did so to gain an advantage. It was a nice business model. Collect all the money, pay no money for labor. It's very profitable.
I mean, the problem with your case is that it's really well established that, and you agree, that mere breach of contract is insufficient to establish a 93A violation, correct?
Correct.
You need some additional factor to bring this into 93A territory. So what is that additional factor?
So let me give you multiple factors. So number one, this was an entire winter of plowing, and there were at least 10 snowstorms. So this was not send an invoice and there was a misunderstanding and it got worked out. This was Green Paradise sent an invoice, got paid initially for the December storm, and then they continued to work storm after storm after storm without notice from Hatch saying, we have an issue with what you're doing. You may not get paid. You need to correct A, B, and C. There was silence. So one, they knew, because there was testimony that Hatch's manager went out after each storm and checked the work that my client did and had no complaints, that my client was relying on that contract to get paid, and they said nothing about withholding money.
So can I just rephrase that in a more lawyerly way? There was an intentional breach of contract by Hatch.
Thank you.
Okay. That's still not a 93A violation in the business context.
No. The excuses that they made up at trial were not identified back in 2019 after the winter when this dispute arose, even despite the fact that my client's first attorney sent a 93A demand. This is not a Section 9 claim, but he sent the demand anyway to try to first learn why they weren't being paid, but second, to motivate a settlement. There was no response to that. The contract that Hatch drafted is significant evidence of unfair and deceptive acts, because the contract on page 2 talks about payment to my client, and the the language says that only the disputed sums would be withheld, but everything else would be paid. So when the customer didn't complain, and the customer paid Hatch 100%, and their own manager, Hatch's manager, confirmed that my client did the job properly, and they failed to identify of the $80,000, what did they say was contested, what did they say was legitimate? Clearly,
Yeah, when Hatch breached that provision too, right?
Right.
It breached by not paying you, it breached by not paying a partial payment.
without a good faith basis.
Yeah, but that's still not
It's still
And
breaching.
the
it's,
additional factor.
you know, Justice Cass, whose portrait hangs behind you, one of our best judges ever to sit on this court, described a 93A violation having to have a certain level of rascality to it. Can you point to something that the jury could have found that would meet that standard?
Yes. So after a few invoices were not paid, my client testified that he went to Hatch and inquired, why aren't I getting paid? I have outstanding invoices. And there was silence. Instead, they allowed him to continue to work without telling him he wasn't going to get paid. And there's a case that I found in preparation for this hearing that's not in our brief. It's the H1 Lincoln, Inc. versus South Washington, 489 Mass 1, that talks about stringing along, in this case, the plaintiff, to induce their reliance. And that's exactly what they did.
But if memory serves, and it usually doesn't, that H1 case that you mentioned has to do with a developer and a development, and there was actual back and forth, and the stringing along, unlike what you've just described here, involved the defendant actually making representations to the plaintiff that things were going to happen to keep the plaintiff on the line. And correct me if I'm hearing you wrong, but I think what you've just said about what happened in this case is that no promises and representations were made.
Well, obviously there was a promise in the contract, but after the invoices were not paid, Mr. Amaral contacted Hatch's manager in charge of paying, who said only Mr. Hatch can decide on payment or not, despite the language in the contract. And they said he would get back to you, and he failed to do so. My client followed up again, according to his testimony, multiple times, but he did not get an answer. He did not, I think the unfairness is not saying we have an issue with your work. And knowing, because their manager saw it after every storm, knowing he relied on the contract, he, meaning Mr. Amaral, did not want to be in breach. He fulfilled the terms of his contract through the winter, and there was still no explanation. Now, 5 years later, really at the jury trial, Hatch's excuse was, you didn't have a GPS on your truck, and so we don't know how much time you spent, or we weren't able to track you, except there was no notice of that issue before, and their own manager said multiple subcontractors had problems with Hatch's GPS. Hatch gave out the GPS. So the jury could clearly infer that that excuse was baseless, that it was not made in good faith.
I agree that we can find that, reading the facts in your favor, but as my colleague points out, you look at H1 Lincoln, and that's a case where there was non-performance, but done so in an attempt to leverage to sort of purchase a different piece of property. Here, the problem is that Hatch just goes radio silent, doesn't make any demands on Mr. Amaral, or doesn't sort of try to, lower the payment. It just goes completely silent, and it's a classic stiffing the subcontractor, but I'm just not sure, I don't see any case that supports that to be a 93A violation.
Well, I think the clear inference is that they wanted Green Paradise to continue to plow for the winter. They had no intent on paying him, yet they didn't want to tell him that during the winter. They wanted him to rely. And their own contract says that they need to give him notice of why they were withholding sums within a certain period of time. They never did that either. So it's not a one-shot deal where it was one storm. It was storm after storm after storm without any notice. That's not fair. It clearly put my client in a position where he didn't know why he was being paid. It was just some delay, so the excuse gave. But ultimately, they made up excuses that after the first storm, he plowed without a GPS and got paid. He didn't know any different. After the second storm, he plowed and got paid. But the next 8 storms, without similar technique, no GPS, he went, plowed, salted. The manager from Hatch confirmed the work. The customer confirmed the work. He had no notice. He would have stopped, or he would have gotten a GPS. He had no ability to correct whatever their phantom reasons were. And the jury clearly found they were phantom, that they were not made in good faith, because there was not one email, there was not a memo, a letter saying, hey, under the contract you needed a GPS, and we're not going to pay you because we can't prove how much work you did. Fine, that would have been fair. Then my client would have had an opportunity to correct the situation, or stop work, or renegotiate, whatever. But without giving him notice, that is the stringing along, the 93A equivalent that the Lincoln case cites. With respect to the attorney's fees, I just want to talk about that briefly. The American rule obviously doesn't apply because there's a statute on attorney's fees. Judge Kenton Walker thoroughly reviewed the bill, and in fact, she reviewed my predecessor, Green Paradise's first lawyer, and talks in volume 7, page 289, that she did not award fees to the first lawyer because she was not convinced his time records were contemporaneous. Then she goes on and allows most of my fees. So clearly, that was an issue that she considered. I also have been before Judge Kenton Walker probably a decade on many cases. She knew me well. I had submitted other legal bills to her. She was aware of our methods, and she also knew the Worcester market. She knew the typical charge of lawyers in the Worcester market with my experience, and clearly she knew the result, which was almost 100%, if at least 90% of the claim. So based on that, her decision on the fees should not be overturned. I appreciate your time. If there are no more questions, thank you.
Seeing none, thank you. We will take it under advisement.
I do have one question, I'm sorry. I put in the brief a request for additional attorney's fees based on the time spent on the appeal. I assume that I would have time after the court's decision to submit a further affidavit.
We'll take care of it in the decision.
Thank you very much.
Thank you. We're going to take a short break.
Court is open. Please be seated.
I hope everyone has successfully silenced their phones now. Our next case is 23P1484, Cynthia Beard and others versus James NAUEN and others. Ms. Brewer.
Good morning, Your Honors. I represent 12 residents of the town of Carver claiming harm from an extensive mining operation that was undertaken by defendant SLT Construction Corporation and approved by the defendant Carver Earth Removal Committee in November 2021. While the law requires that the permit only be granted after a public hearing, and the committee ostensibly held one, it in fact did not let the public speak. Instead, it voted to issue an earth removal permit after SLT presented its materials, but before it permitted any member of
Can you help me with a factual matter? Did they not permit anyone to speak, or did the public not attend?
Actually, a member of the public, a representative of the neighbors, was there and tried to speak and was told she could not until after they took their vote.
The company says in its brief that an attorney from New Hampshire, Margaret Sheehan, spoke
Yes.
at the hearing. How was she able to speak?
She was not able to speak until after the vote was taken.
Oh, okay. So there was public comment, but it was done after the vote.
Exactly, yes. And it was cut short. If you look at the minutes, what she was permitted to say was cut short because, of course, they had already voted. So it was only after that that anybody was able to speak, as I say. What that leads to is, in many material respects, the permit fails to comply with Carver's General Bylaw 9.1, which is the earth removal bylaw. The bylaw's stated purpose is to protect public and private property from damage and provide for safe earth removal activities with minimal detrimental effect on the district in which the activities are located. That's in 9.1.1. But as we would have liked to have pointed out to the committee, had we been able to speak before they voted, the application, the site plan that was presented to the committee, and as a result, the permit itself, are woefully deficient and do not meet the requirements of the bylaw. 9.1.5b states that the site plan shall be prepared by a registered professional engineer. I'm sure you've all seen the one page that was submitted with their application. That one-page plan submitted does not have an engineer's stamp or signature.
I don't want you to run out of time, so can we talk about standing
Yes.
and mootness?
Sure. Yeah, we can get to the questions that I'm certain you have that I would have as well.
Well, these are the questions raised on appeal.
Certainly. So standing is conferred upon a party who shows a reasonable likelihood that they have suffered injury to a legal right protected by the earth removal bylaw. Quite frankly, if these people don't have standing, then I don't know who would. Their affidavits and the complaint itself are replete with significant, specific harms that they have suffered from this earth removal process, which is such things as excessive noise, concussion, shaking of their houses, trash on their property, dirt and sand covering their houses and cars, among other harms.
But all those injuries sort of relate to the earth removal project, right? And that was completed by the time you made any requests for injunctive relief. You filed suit a couple months after the project was approved, but you filed cross motions for judgment on the pleadings about a year and a half later, and by that time the earth removal was over. So maybe, I don't know what the status of the restoration part of the project is, but do you have you need to have standing for each aspect of what you're challenging. What is your case for standing as to the restoration project? What harms are being caused to your clients as a result
Well,
of that?
I want to step back a little bit. With standing being a jurisdictional issue, we're talking about standing at the time the complaint is filed. We
No,
don't.
you have standing throughout a case. You have to have standing throughout litigation and with respect to each piece of injunctive relief that you are seeking.
So we
now
didn't.
I think we're only stuck with the restoration plan.
We're stuck with two things, one of which is that I think what you're talking about goes to mootness and not to standing. I think they have specific harms. I think it is inappropriate to say it only relates to the earth removal operation, because if their restoration plan is inadequate, which is what we claim that it is, and we're entitled to judicial review of that, then we can say that the harms are continuing. Dust, sand, covering my client's property, that continues if the restoration plan is inadequate and doesn't deal with it. They talked about the noise from the removal of the trees and the elevation coming from the highway. If the restoration plan is inadequate and they have not adequately put up any kind of berms or any kind of vegetation or any kind of fencing, noise fencing, that harm continues. So we've never been in a position to say what the harms are now because of the posture of this case.
Can you explain the allegation that SLT is somehow responsible for the appearance of coyotes?
Again, we're talking about wildlife corridors. And if the wildlife corridors have been disturbed by the operation and that continues and there's no mitigation of
There's been a
that.
proliferation of coyotes everywhere.
Well,
Did
all I
you
can
have
say-
some evidence that connects the two?
My client-
Or is it just speculation?
My clients said that, some of them have lived there their whole lives. One of them actually bought her parents' house, the house she grew up in. They had testified in their affidavits that they didn't see the wildlife coming through their backyards and threatening their homes and threatening their children and threatening their pets before this project occurred. So, are we entitled to an assumption that that was caused by SLT? It's a reasonable inference at the least. The standing is important because they never got an opportunity. We're here because they've never gotten an opportunity to tell a court that the Earth Removal Committee had to do its job, that they had to apply their bylaw to ensure the protection of the private property. Instead, they've been told, well, that standing, those harms that you suffered, they don't continue. We don't know that. All we know is that they suffered serious harms and they have asked for a court to review. If the restoration plan that was submitted, which I submit there was no restoration plan, again, we're back to one page, that does not comply with 9.1.5C, then
Cites the language from the requirements.
I can, Your Honor. It's actually a long paragraph. The plan shall include, but not be limited to, pertinent information on the following. And I will, if you don't mind, I would skip over the parts that don't apply, such as roads.
My only question is, isn't the language on the bylaw included as part of the restoration plan?
No. There is no restoration plan. There's one page. And there is nothing in the decision of the Earth Removal Committee that makes any reference to that.
Well, the record is that the ERC approved the restoration plan, so there must be something.
All there is a condition that SLT will contour Ms. McGrath's land with the subdivision property according to the presented plan. That's the one page we're talking about.
Where is that?
Appendix 1, page 70 is the start of the decision. It's paragraph 4. Re-landscaping with a mixture of pine, oak, grass seed, and wildflowers. Refer to the attached map for reference. The map says nothing other than grass, wildflowers, and makes a reference to some trees. There's
no reference to the creation of a berm?
There is a reference to the creation of a berm, which no engineer has said is adequate.
Okay.
9.
There's a reference to a berm, wildflower seeding, planting of trees, and the grading and landscaping of the property, right? Those things are all included in the plan.
They are. We have no idea how many trees. We have no idea whether they are native species for grass. You can see on the plan that there is a tremendous topographical change between the SLT property and down to Ricketts Pond. And there is nothing in there that talks about erosion control. There is nothing in there that says whether the plantings that are there are ones that are going to, in fact, protect from any kind of runoff into the Ricketts Pond. And again, going back to 9.1.5C, the restoration plan is not only supposed to comply with sound engineering practices, of which we have no record, but it also is supposed to comply with either of two codes under the Natural Resources Conservation Service Conservation Practice Standard. There are two standards. Neither one of those is referenced anywhere. They were not reviewed by the committee, and they are not referenced in the decision. Why is this important? Because if one goes to look at those standards, one sees that they have specific requirements on how existing mining operations are supposed to be reclaimed and restored. They are technical, they are specific, they talk about things like erosion control, they talk about such things as erosion, none of which is dealt with here. Why is that important for the neighborhood? The neighborhood has had sand and dust and gravel covering
But
their...
that part of the operation's done.
No, we don't. All we know is that they're saying earth removal is done, but not that there's no more dust or sand. If the restoration is...
The harms you illustrate in your brief are all, this may happen, and this could happen, and this could happen. But speculative harm isn't good enough.
Speculative harm is not good enough. It is not speculative that they have...
Why isn't this moot?
Now, mootness is a different issue. Mootness, I submit, is when the party who has a personal stake in the case can no longer receive effective relief from the court. That is not this case. Again, we're arguing...
You didn't seek to enjoin the restoration.
Yes, for several... Let me address that one as well. So, a preliminary injunction is not a necessary predicate of going forward with a cert action. I think we can all agree to that.
No, I'm talking about why isn't it moot?
Yes, and it is not moot because we can still get effective relief, and that is we can still get judicial review of the permit for whether it is an effective restoration plan. We don't have that. We do not have any court that has found...
What would you... Let's assume a judge were determined that it was not an effective restoration plan. Then what do you get?
Then what we'll get...
Satisfaction?
A remand to the ERC, to the Earth...
You didn't ask for a remand in your motion for judgment on the pleadings.
We asked for invalidation of the permit. And when the permit is invalidated, it has to go back to the Earth Removal Committee.
And then what?
Sorry?
And then what?
And then we get a review of the restoration plan. One of the critical things...
In the best case scenario for you, what happens?
The best thing that happens is they go back and they are required, SLT is required to do a sediment control plan, to locate the sources of water, to locate the primary recharge areas, to provide the existing ground levels of the groundwater, to note the natural surface flows, and determine if the noise can be mitigated, if the sand and the gravel that's been blowing on my neighbor...
Excuse me, I'm sorry. These are requests that you've already made in Superior Court.
Yes. And we've never gotten an opportunity for a court to say, this is not appropriate. What they did is not adequate, and we're entitled to that. We're entitled to judicial review of this permit in order to mitigate and ameliorate the harms that have been caused by this operation. I do want to address some of the issues in, you've raised the undue delay. I'll have you know that we filed suit within 2 months, actually within 1 month, of the permit getting filed with the town clerk. Immediately, there was a motion to dismiss. That motion did on standing, which was denied by Judge Sullivan, and therefore, it was not, we filed within 30 days of the certified administrative record being
Thank you.
filed.
We understand.
Thank you.
Thank you. Mr. Ferguson.
Good morning, Your Honors. May it please the Court, my name is Bob Ferguson, and I represent the appellees SLT Construction Corporation and Marab Trust. My sister talked about the question that she is posing, and that is whether or not there has been an effective restoration plan. That was the thrust of her argument. In their brief, the residents argue that SLT, quote-unquote, flouted the requirements of the earth removal bylaw. They also contend that the ERC, quote-unquote, abdicated its responsibility to review and require an adequate restoration plan. So what is it ultimately that the residents seek? The residents seek, as Ms. Brewer just described, a remand to re-review the restoration plan that the ERC reviewed, inquired about, inspected, and ultimately approved and permitted on November 23rd, 2021. My sister referenced that the residents should have an opportunity to examine that plan and to challenge that plan. That opportunity occurred on November 17th, 2021.
There's an allegation, and I apologize, I didn't write down where it is. There's an allegation that the parcel was misidentified in the public notice about the meeting. What can you tell me about that?
I believe that's a reference to the agenda that was posted for the Earth Removal Committee meeting. So the property owner was correctly identified. I think the parcel number, I think it said map 22 instead of map 23, lot 4. So it said map 22, lot 4 instead of map 23, lot 4. But the owner was correctly identified, and notice was duly given in the Carver Reporter.
It was misidentified on the meeting agenda, not in the public notice.
Correct. The public notice, the Carver Reporter, I think there were 2 advertisements. It's in the record, and they correctly identify both the map, the parcel number, and the property owner. Attorney Brewer referenced that a member of the public attended. Attorney Sheehan, she's in the courtroom with us today. Clearly, notice was sufficient for her to have attended that hearing. So again,
the merits aren't really before us here, right? The question is, are mootness and standing barriers to further proceedings in this case? And I think there's a strong argument that the earth removal process challenges that are moot. I think there was essentially a concession that they didn't want to restore the earth. But I think their best argument is that even though the removal of the earth is complete, they're entitled to pursue their claims as to the restoration plan because that restoration plan is designed to ameliorate harms that they contend are ongoing. So why isn't that sufficient to get around both mootness and standing as barriers for further proceedings here?
yeah, I mean, I think honestly their best argument that the case is not moot is that, well, geez, if the restoration plan is inadequate, perhaps more trees need to be planted or something to that effect. And so both with respect to standing and mootness, both legal issues do have some overlap with the merits of the appeal. This is a motion for judgment on the pleadings. I believe the court can uphold or affirm the Superior Court's decision even on grounds that the Superior Court didn't articulate. So even when it comes to mootness, all of that stems from an assumption that the restoration plan was inadequate and that the ERC didn't appropriately review. The residents in this case, they still have to demonstrate that there was some legal error and there was arbitrary capricious conduct when it comes to the review. And in that regard, I do think that there is an overlap between both standing, mootness, and the merits, namely the adequacy of the restoration plan, which is more than the one page.
At least for one, I'm not eager to affirm the decision below on an alternative basis going to the merits. If the decision below was done based on mootness and standing, those are the issues that really need to decide. And so my question to you is, why don't they have a case that they are suffering ongoing harms resulting from what they contend is the inadequate restoration plan? And shouldn't they be allowed to pursue those claims in the Superior Court?
Yeah, they should not be allowed to pursue those claims, and they don't have a case because there is no evidence in the record of any harm relating to any restoration work. The only evidence in the record regarding harm related very specifically to earth removal operations. And there are two problems with that evidence. So there are a handful of affidavits that were filed at the motion to dismiss stage. And what they said very specifically was that the residents were incurring alleged harm resulting from noise, concussive noise, vibration, movement of earth, what have you. But it was all SLT's earth removal operations. I re-reviewed the affidavits. They're all very specific. Not one of those affidavits references earth restoration, which is defined very distinctly from earth removal in the bylaw. So you've got allegations regarding earth removal on the one hand.
Well,
nothing in the record.
and I think I take your point, but
Yes.
probably the reason why the affidavits don't address the restoration, because the restoration wasn't happening at that time. It was in the earth removal stage, right?
At the motion to dismiss stage, correct.
Yeah, so I guess, but it's somewhat tricky to separate earth removal from the restoration part, because the restoration project's obviously designed to ameliorate the impact of the earth removal. So your argument is that all the harms they've identified are specific to the removal, and they haven't identified any subsequent injuries that relate to the restoration project. I assume they would say, well, we're still experiencing dust and dirt, or the increase in the coyotes or whatever due to the earth removal, and there's been inadequate effort to fix those problems through the restoration project. Why wouldn't they have standing to pursue that claim?
Again, there's the only thing that you have on that point about this ongoing harm, or that the earth removal, or that the restoration hasn't ameliorated the earth removal, is what the lawyers put in their briefs. It's legal argument. And if you look at the appellant's brief, it's all, it may, continue, or the noise may not be adequate, or there, may still be dust. There's still nothing in the record, and there was nothing to prevent the residents from submitting information at the motion for judgment on the pleading stage, where they were looking. These cases under certiorari, under Superior Court Standing Order 196, are decided on the record. It's a motion for judgment on the pleadings in lieu of a trial with live testimony. That was the residents' opportunity if they felt, and at this point we had already advised them, not only that the earth removal was complete, but that the earth contouring was well underway, and the earth restoration was all but complete, except only for the planting and seeding that was left to be done in October of 2023. That's the planting and seeding season. So despite my sister's references to Code 342 of the U.S. Department of Agriculture, one of the indications there is that you have to choose vegetation that is going to be planted and seeded at an appropriate time and appropriate site species. Is all stuff in the record on that point. So they had an opportunity at the motion for judgment on the pleading stage, where they argued on the merits. They had every opportunity to submit whatever evidence they had available to them regarding the restoration, because they knew at that point that the earth removal was complete. They did not withdraw their brief. They did not pivot and make any written request focused solely on restoration. Restoration was really just one of a laundry list of issues that they had included in their briefing. So I showed up to court in the Superior Court in August of 2023 and was taken a little off guard when the residents completely pivoted and asked for a remand to talk about the adequacy of the restoration plan. At that point, again, no evidence in the record whatsoever to suggest that the restoration plan, A, failed to comply with the requirements of the bylaw, B, that the earth removal committee either acted arbitrarily or capriciously in approving that plan or committed some legal error in approving that plan.
Is the restoration project done?
To my knowledge, yes. In fact, the ERC, I put a motion in for judicial notice just so the court could take notice of the fact that the ERC has closed out that permit, and it's attached as an exhibit to that motion.
What if some of the supposed harms come into being in the future? Is there any available remedy for the residents at that point?
I think so, yes. The ERC has very broad authority under the earth removal bylaw. They have responsibility to monitor and inspect sites. They have enforcement authority, if I remember. So
If the water table was interrupted in a way to cause damage to someone's property, that could be remedied.
I believe so, sure. Yeah, and again, I mean, on certiorari, my sister mentioned that, you look at that at the time of the lawsuit, that's all well and good, but from the very outset, the allegations of harm really do not arise from the underlying proceeding itself. The allegations of harm, and I believe she said it in her opening statement this morning, the allegations of harm arise from the conduct of SLT, the alleged conduct. They're claiming harm from the defendant SLT's operations, the earth removal operations. So that's a nuisance or a tort claim. So in terms of certiorari, you have to demonstrate that there's no reasonably alternative or adequate remedy available to them. So if they felt that SLT had deposited dust on a car, I think they would have a cause of action against SLT, but that doesn't necessarily mean that the court reviews the decision of the ERC made after a hearing that none of the residents attended, okay, and now 3 years later in a position to remand back to the ERC to determine whether or not the restoration plan it reviewed in November of 2021 was appropriate. All that work is complete now. And it was reviewed and inspected by the ERC. And because of the timing of this, some of that information about the completion of the restoration work is not in the record. So I want to be clear about that.
Well, I mean, I guess it's a good point that certiorari action's about the actions of the ERC, but you're saying there might be private causes against SLT directly based on how they carried out this project?
Sure.
Or have the statutes run on those claims? I mean,
this hearing was 2021, 3-year tort limitations. There's no, I mean, they contend that they were aware of earth removal operations several years ago, so whether or not the statute is run is...
Ms. Brewer says in her reply brief that although there are tort actions that are available, that was not the remedy they want. They want a judicial review of the ERC process, which they can't get through a tort action.
That's correct. They wouldn't be able to get that through a tort action. It would be an action for damages. But I don't think that certiorari allows an applicant to pick and choose its remedy. I think the idea is that it's available to those people who have no other alternative means of relief.
I guess it wasn't so much the remedy it was the actual relief that they wanted. What they saw was review of the ERC, and a tort action isn't an available remedy to get that.
Yes, that's correct. The tort action would be separate from damages, but I don't think that the certiorari statute, it refers to no alternative remedies. So there are no other adequate remedies. And so, again, if the allegation is harm...
So it doesn't have to be specific to what they were seeking under cert?
I don't think so. I don't think so, and I don't think my sister has cited a case to that effect. I'm not aware of it. Certainly arguments can be made, that, hey, look, we're looking for a review of the ERC, but again, then you get back to the standing questions and certiorari and the stringent standards of review. In my mind, the allegations of harm, the very little allegations that are in the record, really don't rise to the high level required for certiorari review. I was sort of thinking if I were an applicant and I wanted to install, let's say, a septic system on my property, this is maybe a little far afield because it doesn't necessarily pertain to earth removal, but if the committee had denied me a right to install a septic system and therefore I couldn't live in my house any longer, something to that effect, there would be no other adequate remedy for me. I've got nobody to sue. The only recourse I have is to go to the court and say, well, geez, they prevented me from doing this, but the bylaw says I can do it right here. That's what certiorari is for.
You said that the ERC signed off on the restoration, the completion of the restoration project. When did that happen?
I would say it happened on November 23rd, 2021.
Is that a separate action for which the residents could potentially bring a new action challenging that determination that it was not adequately restored?
Yeah, I think honestly, yes. I think, the bylaw grants broad authority to the ERC. And so if there were complaints about compliance with a permit, whether or not the permit was adequate after it had been issued, I do think they probably could have gone to the ERC. There's no evidence in the record that says that they submitted.
But they could do that now, potentially, if they were able to show injuries related to the purported, government action that they wish to challenge. If they could show causation and injuries that they're suffering now.
Right, right. I think that they would have to demonstrate some sort of a causal connection, and they'd have to demonstrate that the restoration plan was inadequate. And
Right, on the merits, right. I'm just
On the merits.
in terms of bringing new action. Okay, thank you.
On the merits, exactly. And, you know, there was more than just one page of the restoration plan. When SLT submitted its application, it included a copy of its, redacted copy of its contract with Mary McGrath and Marab Trust. And that include details about grading and landscaping, the construction of the earthen berm, the composition of the berm, the reuse of soils. Again, my sister references Code 342. They do not argue that in their briefs. They make passing reference to it, but they never, at any point, despite arguing that the restoration plan was inadequate and that the ERC abdicated its responsibility, they never, you know, compare the two and say, here's where we fall short. Again, I would direct the court, in particular, to page 137. I think that's the clearest of Volume 2 of the Record Appendix. I think that's the clearest reproduction of the site plan, as well as pages 108 and 109 of Volume 2 of the Record Appendix. That's the contract requirements. SLT submitted very specific information. And the ERC, 3 members of the ERC, not only, I see that I'm running out of time, if I can just finish this thought, and then I'll be done.
Yes, go ahead.
At the hearing, 3 members of the ERC asked questions very specifically about the berm, the plants, the seeding, the trees, the location of the trees, the size of the trees, wildflower mix, and then when Attorney Sheehan asked very specifically about the fully complete restoration plan, which is as determined by the ERC, Mr. Geronimo, the chairperson, confirmed that it complies with the plan, and it's all in the record.
All right. Thank you.
Thank you.
Thank you, Mr. Thank you, Bull. We'll take it under advisement. Our last case is 23P571, John Lundgren versus Robert Hofer and another. Okay, before we start, I think you've seen how things work today.
Yes.
Okay, so you're going to get the opportunity to speak. You're going to get 15 minutes.
Correct.
You're not required to take all of your time.
Right.
We may ask questions. Your counsel on the other side are not going to interrupt you.
Okay.
And I ask for the same when they argue as well.
Okay, great. Thank you.
Go right ahead.
May it please the court, I am John Edward Lundgren. I'm a pro se appellant in this case. I thank you for your time. I stand before you today surviving a motion to dismiss, interlocutory appeal, and my evidence has resulted in many attorneys filing notices of withdrawal. Neither of my hired counsel, the appellees, ever utilized my medical release authorizations for the intended purposes for which they were signed, as any other attorney would have done. These forms are the key to my case because they do not exist. Their inability to produce proves malpractice and so much more. The medical records are the foundation and the principle of every case. Fundamental principle is that a judge cannot grant a motion of summary judgment unless all the facts are undisputed. Summary judgment, unless all the facts are undisputed, first and foremost, my rights for due process under the standard civil procedure was denied, particularly regarding the hearing on the impounded records of Attorney Belluti and the Board of Bar Overseers. The lower court overlooked 2 critical voicemails which were present to me on the day of the motion for summary judgment hearing. If they had heard the impounded records, she would have not been able to file the summary judgment in that motion. So I believe that you have seen the impounded records. Had this evidence been properly considered, I'm confident that it would have fundamentally altered the outcome of Judge Susan Sullivan's decision. The panel of justices has since reviewed the impounded materials and the letters of all my providers, which prove that they have never sent any authorizations to any of my providers. These voicemails that I had with me on the day of the summary judgment hearing pertain to Belluti's failed representation, and furthermore, the evidence of his inability to produce these key documents which he relies upon in his answers to the BBO. There was also false certificates of service that were served a number of times. And the facts of this case are simple. My employee's response to Gordon Air Quality Report recommended water samples if an employee working at the facility was diagnosed with Legionnaire's disease. I was that victim. In any case, the protocol is to trace the patient's movements to identify the source of exposure. Nearly dying from this disease and suffering long-term consequences, I was denied the basic investigation step of trying to find the source of my Legionella. You know, had an air conditioner in here malfunctioned and emitted a thick vapor, and a couple of days later, one of us contracted Legionnaire's disease, you could bet your bottom dollar that they'd be in here at that site to take water samples. That's what I originally hired these attorneys for, based on the company's Gordon Air Quality Report, which recommended samples if anybody in the facility had contracted Legionnaire's disease. As for my attorneys, their action was not only unprofessional, but demonstrably dishonest. I was referred from one attorney to the other in a manner that can only be described as criminally suspicious. My first task they asked me to do was 5 medical release forms, allowing them to obtain all my medical records for the purpose of zealous representation. However, not even one of these forms was used for its intentional purpose by either attorney. This is not merely an assertion, but a proven fact. These exhibits include the letters and sworn affidavits attesting to this fact. You know, years ago, I contacted the opposing counsel and said, if you can show me the medical release forms that you authorized, that I signed, and some of my wife had signed as a witness, that you had utilized in order to get my medical records, I would drop this. They could not produce those. They kept producing medical authorization forms that I signed, but not sent to the providers, or not even filled out to the providers. Not one medical record that they received was received through a medical release form, which, when I signed the retainer with them, they promised me zealous representation. Not sending any of these medical release forms is not zealous representation.
Can I ask you a question, Mr. Lundgren?
Yes.
Did you ever try to obtain the medical records by yourself?
Excuse me?
Did you ever, on your own, try to obtain the medical records?
Actually, we did. We asked numerous times the opposing counsel for the medical release forms that were utilized, not the ones that were blank and not sent out to my providers. They could not produce them. We asked them numerous times.
Oh, but did you ask the providers directly for your medical record?
And all the providers, and it is when he impounded these records, he claimed that it was for my behalf. I had nothing to hide. In response, it was because all my providers have sworn under oath that they never received even one medical release form from either attorney.
Oh, I'm just asking, I understand your point
Yes.
as to what your attorneys did not do, but did you yourself try to obtain your medical records? Did you submit a directly?
We did a couple of, definitely not an adequate amount to represent my case.
Yeah.
But we did send a few medical records to them. And it wasn't just that they forgot a couple of medical records. They never addressed a whole week of hospitalization. I still have outstanding bills. They never paid AMR ambulance from Morton Hospital to Sinai Hospital. They never acknowledged Sinai Hospital. There was a number of things that weren't, that was never addressed. I was told to put my medical, my meds through my own personal insurance, which shouldn't happen on a workman's comp case. And my case against Attorney Hofer is extremely viable and proven by all the material evidence that presented to the court. He was hired to represent my workman's compensation case, and I was referred to him by Attorney Belluti, and their actions are criminally similar. Under the workman's compensation law, the medical records are the foundation. The law requires payment for all reasonable related hospitalizations, doctor's appointments, prescription medications, and more. Due to Attorney Hoffer's obvious gross negligence and proven suppression of my medical records, providers are still not paid accordingly as ordered in the original case. Attorney Hofer never utilized the medical release authorizations as any other attorney would have done under the circumstances. I know the panel has seen my letters providing these facts, and the fact is apparent and obvious to a layman that my DIA file omitted voluminous critical medical records. I mean, my DIA file that he filed was missing the AMR ambulance, the week hospitalization. It was not a true attest of my situation.
Mr. Lundgren, I'd like to ask you a question about what happened at the DIA, and this is based on something that is in Mr. Hoffer's brief, so I'd just like to get your memory of it. Mr. Hoffer says in his brief that you, at some point during the proceedings, I don't know if it was in your deposition or at the hearing on the motion for summary judgment, you said that even before you agreed to the settlement of your DIA claim, you were unsatisfied with Attorney Hofer, thought he was not representing you adequately, and that you went and looked for other lawyers. Do you remember whether that actually happened?
I've been looking for numerous lawyers all along throughout this case. When I first hired him, I put my trust in him. I was not aware that the DIA file was omitting all this information. I put all my trust in him. As far as me looking for lawyers, from the very beginning, even when I had counsel, I still was researching lawyers. I found, and I am pro se, that it's extremely hard, and I've called 100 lawyers and had intakes and sat with lawyers, and I found that it's hard to get a lawyer to go against another lawyer. And as Attorney Robert Hofer said to me and rubbed it in my face, good luck getting a brother to go against another brother.
Do you remember, this is another question from the record, when you filed your motion for reconsideration. You remember that after the summary judgment decisions, you filed a motion for reconsideration?
Yes.
Do you remember how you sent that to the lawyers, in other words, to Mr. Hoffer's lawyer, Mr. Berludi's lawyer? Did you send that in the mail? Did you send them an email?
We've sent numerous documents to them, and most of the time it's in the mail. Via email is not something that I do.
Okay.
But in that aspect, there has been numerous questions on the way that they have submitted their information to us, as far as the way that they mail things and things like that. So there's been a lot of questions on the way.
You put your things in the mail. Was that your practice?
Some things we put in the mail. Most things were certified, and we've kept all our receipts and everything, so we know that we sent them in the correct manner.
I'm looking at a letter in your record appendix. It appears on page 170 that is addressed to Attorney Moriarty, Attorney Grossbaum, and Attorney Scamby, that says, attached, please find Mr. Lundgren's motion for reconsideration in response to the granting of Robert Berludi's motion for summary judgment. And then there's a date, a handwritten date at the bottom of that, 7/22/2022. Do you know if that letter is something that you actually sent on that date?
I would have to look back. I wouldn't remember. That's partially part of my problem, is since I've had Legionnaire's disease. I mean, I had tremors for 2 years. I progressively got worse as far as muscle tightening and things like that. So, in my memory for the first couple of years was really off. I can't really remember a lot of things. And that's why I asked my wife to speak for me, because some of these questions that you may ask me, I won't be able to respond in the proper manner. So.
You're just about to run out of time, Mr. Lundgren, so if you could just quickly summarize what you'd like us to do, please.
Okay. So Attorney Hoffer and Attorney Berludi never utilized my medical records as I authorized them to do, and that he continuously relies upon in showing me the blank authorizations. And the fact is obvious to a layman that medical records, the fundal primer for all workman comp cases. So to have them not receive them, and even the independent doctor and the impartial doctor were asking for some of the medical records that weren't in the submissions that they had.
I think we're out of time now. You've gone over, so we're gonna leave the rest to your brief.
Okay.
We'll hear from Mr. Grossman. Excuse me, Grossbaum.
Excuse me, that was 15 minutes?
Yes, sir. It was on a timer.
All right, thank you.
May it please the court. My name is David Grossbaum. I represent Attorney Robert Hofer. With me is Attorney Rowan Moriarty. I just wanted to address Judge Hershfang's question, if I could. The record citation for the question you asked, Justice Hershfang, is Volume 9, page 55, which I believe is Mr. Lundgren's deposition testimony. We would never have known that he spoke to other lawyers unless he told us. So that was not information my client had at the time. So that's where that comes from.
Thank you.
Justices, this case is about a plaintiff who claims that a settlement that he signed, the benefits of which he accepted, was too low. He's claiming that his lawyer mishandled the settlement and that if his lawyer had acted differently, that he would have received a larger settlement. He doesn't have an expert to say that Attorney Hofer breached his duty of care in handling the settlement, and he does not have an expert to testify that he would have gotten a better result but for Attorney Hofer's conduct. Therefore, the judge properly granted summary judgment for Attorney Hofer. Keep in mind, Your Honors, that this was a hotly contested case from the point of view of Travelers Insurance Company, which was the workers' comp insurer. They disputed everything. They disputed that Mr. Lundgren acquired or contracted Legionnaire's disease at work. They denied that whatever disability he was claiming was related to the Legionnaire's disease. They denied that he actually had a disability at all, and they certainly denied that he continued to have a disability. So in that backdrop, Attorney Hofer was confronted with a situation where he was going to need to prove, on behalf of Mr. Lundgren, every single element of the case. Attorney Hofer, to his...
Mr. Grossbaum, the judge in the Superior Court noted something of a dispute as to whether Mr. Hofer requested the additional medical records from the plaintiff's providers, which would have been helpful both to the doctor retained by Travelers and to Dr. Friedman, the doctor who was independently appointed under the order of the DIA judge. And the judge specifically considered as evidence correspondence from various medical providers stating that they did not receive requests for the medical records from Mr. Hofer. So assuming that there's a material issue of fact as to this purported failure to obtain the medical records, is that an issue that necessarily requires an expert opinion for support? It's arguably self-evident that you can't fully assess a claim for medical damage without all available medical records bearing on that injury.
Sure. So a couple of things, Your Honor. Number one is records from every provider are included in the DIA file, and they were provided by Attorney Hofer either in April or July or October. And those, I have references in the record where you can find all those records. The only exception is the Sinai Hospital, which was a hospital that Mr. Lundgren attended after he had already been diagnosed with Legionnaire's disease and treated for pneumonia at Morton Hospital. They discharged him. Apparently, he wasn't actually all the way cured, so he went back into Sinai Hospital. Those Sinai records are really irrelevant to the summary judgment issue, to the issues in the workers' comp, because there was nothing about that hospital stay that sheds light on whether he contracted Legionella, where he contracted Legionella, whether he's cured from Legionella, or whether he's continuing to be disabled. So admittedly, those records are not in the DIA file, but all the other records are. And the reason that expert testimony is required is that these allegedly missing records, which are never really identified as what those are because all of the provider's records are in the DIA file and provided by Attorney Hofer, he needs to establish somehow that these allegedly missing records are actually material to the merits of his case and that they would have resulted in a better result for him somehow. And so he needs either a legal expert or he needs a medical expert to say these records, which have never actually been specifically identified, that weren't provided, he's got to show that they were important as opposed to being simply redundant. He needs to show that the medical records, in addition to not being redundant, are actually helpful. Because as you can tell from the record, Your Honor, some of the medical records that were produced were not helpful to Mr. Lundgren. Particularly, there was significant evidence that he was a half a pack of cigarettes a day smoker for many years, and he didn't stop until after the accident. And the medical professionals diagnosed him as having COPD, and the claim of disability was largely based on respiratory difficulties.
So your position is that just the mere fact that there might be evidence that certain requests for the records weren't provided isn't sufficient. You need to actually have the missing records and establish why they would have been material to the claim to support.
Exactly, Your Honor.
Okay.
And this claim which we've heard today and which is in the brief about how the medical records were not obtained through releases that Mr. Lundgren provided to Attorney Hofer, Attorney Hofer had all the records. That can't be disputed, and they're all in the file. And whether or not Attorney Hofer physically used the releases or whether the Lundgrens provided the records, and that's what Attorney Hofer has said, that he received the records through his clients, is really immaterial because he had the records. They were provided to the DIA, and they were also provided to travelers. So,
Can I jump in and ask a question that I've already asked Mr. Lundgren? But in terms of the motion to reconsider, you and your brother both argue that the only thing before us is the denial of the motion to reconsider and not the actual summary judgment rulings themselves.
we actually don't, Your Honor. We don't.
Okay.
We don't make that argument.
Okay.
We understand that Attorney Berluti's lawyer did.
Okay.
We just decided to go.
You all look the same, you know.
Yeah, I mean,
we all look the same.
Yeah.
Can I ask you another question then? With the filing of your supplemental record appendix, would you agree that the record is now sufficient for us to consider Mr. Lundgren's appeal?
The only thing I noticed, Your Honor, is when I was going through the record appendix and the supplemental record appendix to prepare for the argument, I realized that we did not provide, and I should say we, it's really Mr. Lundgren's obligation to provide the entire summary judgment record that was before the trial court. So I think we thought about it and thought about filing a motion to supplement the record, and we could certainly do that if Your Honor would like. But it was our understanding that as the appellant, he was the one that had the obligation to give the court the full summary judgment record if he's challenging the summary judgment decision. We are at police here. I think the record's complete with that caveat.
Okay, thank you.
I'm out of time. I'm happy to answer any questions you might have.
Seeing none, thank you. Mr. Byrne.
Good morning, Your Honors. May it please the Court, Michael Byrne for the appellee, Robert Berluti. I did want to just briefly address the motion for reconsideration because we have raised that in our brief. And it's our position that the summary judgment and the final judgment that entered on that summary judgment were not timely appealed within 30 days after the entry of final judgment. There was a motion for reconsideration filed, which could have been treated as a Rule 59 motion and stayed the running of the appeal period if it had been filed within 10 days of
It has to be
the problem.
served within 10 days, which is why I'm asking all of these really dorky questions about service. And so in Mr. Lundgren's appendix at page 170, there is a letter from Mr. Lundgren addressed to counsel for the counsel. It gets confusing in these cases, saying, attached, please find Mr. Lundgren's motion for reconsideration. So that is the only thing I have been able to find in the record. Admittedly, I have not reviewed every single page reflecting a service date for the motion for reconsideration, and that's why I'm trying to figure out what else may be in the record about that.
I was not involved in the case, as you know, at that point of the litigation, and I'm happy to take a look at that.
It seems they were filed together in a 9A package because the opposition was there too. Mm-hmm. But as Justice Hershfang said, the time in state court runs from when it's served. The federal Rule 59E uses filed.
Understood. I also know that this was the subject of some argument in the Superior Court in the context of the motion to strike the appellate, the notice of appeal, and what the court said in response to that was that, well, clearly the notice of appeal is limited to the motion for reconsideration, and that's the only issue that's going up. You know, given my limited time, I'm certainly happy to answer whatever questions you have on that point, but
that was my only question.
I think, and I can take a look at the record and see if I can come up with any additional information.
We're going to need the date of proof of service.
Okay. I will, I'll see what I can do, and if I can find something, I will.
Otherwise, the appeal is timely.
Okay. As far as the substance of it is concerned, from Attorney Berlutti's perspective, we not only have an issue with the expert evidence, but we have a more fundamental issue, which is the statute of limitations. And here, all of the events that pertain to Attorney Berlutti's involvement took place between January and June of 2015. Suit was not filed until December of 2018, 3.5 years later. And there is no evidence that anything of significance happened after December 2018, which could have served as a trigger for the accrual of the cause of action. To the contrary, Mr. Lundgren at his deposition basically conceded that all of the evidence that he has, all of the opinions that he has as to things that Attorney Berlutti did wrong or failed to do or was not as assertive or aggressive or proactive about doing happened during the period that he represented him, and he was aware of them at the time. The argument is that he was not sufficiently aggressive in attempting to get water samples from the employer, that he didn't, there's been a lot of discussion about medical records. Frankly, I don't see how that really matters. Maybe it matters from the comp perspective, but at this stage of the pre-suit proceedings, making sure that you have every single one of the plaintiff's medical records isn't necessarily something that an attorney has to do first thing out of the gate. When your primary concern in a case like this, which would be a claim against the manufacturer and or the servicer of the machine, is trying to demonstrate a causal connection between whatever happened to the plaintiff and that piece of equipment. And in that regard, all of that information was known, as was the fact that not all the medical records were allegedly not obtained, but all of that information was known by the time that the relationship ended in June. His dissatisfaction with Attorney Berlutti's performance, he has made clear, was an ongoing thing. So as a result, there is nothing which would take this case outside the statute of limitations, which would push the accrual date forward until after 2018. Really the only thing that happened, after December of 2015, really the only thing that happened in the 3 years prior to the filing of the suit that is of any significance is that they received a copy of the NIOSH report from the NIOSH investigation, which was sent in 2016. And that report torpedoed the plaintiff's case. It simply underscored the fact that there was no finding that there was any Legionella bacteria on site. And in fact, even if there had been Legionella bacteria, what that report indicates is that it would have been cooked off when the machine was turned on, because the bacteria can't survive above 150 degrees, and this was 180 degrees when it was running. So 6 weeks after the incident, they hire Attorney Berlutti. It's too late at that point for him to collect samples. And if it weren't, and I'm not an expert, but if it weren't, you would need an expert to show that. You'd need an expert to prove that Attorney Berlutti's conduct fell below the standard of care, and that he should have done more, that he could have done more. And you need someone, a scientist of some sort, medical expert or some other scientific expert, to establish that it would have made a difference. That if you had done more, you could have found something, or would have found something which likely would have given rise to a viable claim. And he can't do that, and he didn't do that. And so from our perspective then, what we have here is a situation where the suit was filed too late, subject to what we've talked about with the motion for reconsideration. It appears the appeal was filed too late, and there's insufficient evidence to establish either what Attorney Berlutti should have done differently, or to establish that how the case would have turned out differently if he had. And without any of those pieces, and given the untimeliness, we believe the summary judgment was properly entered and should be affirmed.
Thank you. Thank you all.
Thank you.
With that, I'd like to thank my colleagues, our law clerks, our court officers, our clerk staff, and our excellent timekeeper. And with that, we'll stand in recess.